how should they go about writing research papers, internships? So if you can lay down certain points which can guide them to enter into this field if they wish to.
Hotel industry as their clientele or hospitality industry as their clientele, they would purchase a lot of artwork.
Right.
See if you can, propose them some ideas.
To have like a better control on some issue which you think during your practice that needs to be resolved.
People are appreciating, but I see it only in metros.
Right. Hi everyone. Welcome to the Lex Global podcast, an initiative by Physics Wallah. Our aim is simple yet powerful, to cut through the noise and give you real insight into law. Not just certificates that certify, but skills and perspectives that equip you with precision and confidence. At Lex Global, we are not here to flood you with content. We are here to sharpen your edge by bringing with you to conversation with leading practitioners and thinkers who are shaping law and policy in real time. This is what sets us apart from the market. Where others may promise certificate, we focus on better outcomes, deeper learning, and results that truly matters. Starting our podcast, we have our first guest tonight, that is Subhash Bhutoria. Man needs no introduction. However, for refreshing everyone's memory, I will just give a brief introduction about Subhash. Subhash is a seasoned Indian lawyer specializing in intellectual property rights and art law. Yeah, you heard it correct, art law. He has a career of over 15 years, has been working with leading law firms of India like Lal and Sethi, Lakshmi Kumaran and Sridharan, Luthra, and also under his belt, credit to founding IP and art law practice at a legal boutique law firm, Creedar Legal. I don't want to mention the client's name, but on a no-name basis, he has represented almost everyone, listed entities, big name, e-commerce, every possible sector which needs legal representation. Subhash has helped them in various capacities. Subhash is also a member of different committees, not to name the all, but including European Community Trademark Association, IP Forum, FICCI, World Craft Council, etc. Much to his credit, he also owns and operates India's Maiden Art Law blog, which is www.artlawindia.com. I will request you to check because I have been through that website, really encouraging. Welcome, Subhash. Thank you for taking out time.
Thank you so much, and it's wonderful to be part of this podcast series. Looking forward to a great conversation today.
Same here, Subhash. So without any further delay, I will just jump to a list of questions which I have prepared for you. So, Subhash, our intention is to allow all the listeners to take you through your journey to understand that how have you developed this niche right from your law school, how it has evolved, what has been your journey so far, and how it has been going right now. So, coming to my first question, I would like to understand what inspired you to pursue law, and how did you find your way into intellectual property rights, and especially in arts law?
So law happened accidentally. I was preparing for medicals, and I come from a remote area in district Mirzapur.
Okay.
You might have seen it.
Yeah.
So from in our area, either you become an engineer or a doctor. So there's no third profession that generally people pursue. When I got to know about law, as at least 5 years law, I was intrigued and I was interested in pursuing it, wanted to explore it first. And when I went to law school, probably I had no clue whatsoever how to read law, how to understand, interpret, and construct law and legal practice as such. In fact, it's very funny. So in our law school, I went to National Law University, Jodhpur. The first course was with regard to torts. That is the basic of law that most of the law school teach. And it was our courtroom exercise, which is moot court, pretty popularly known as moot court. And I was told that it is almost like a debate. So I thought, it's a debate, we can just do it, just like that. But there is a technicality involved in moot court competitions, and you are required to prepare a preposition, you're required to have a jurisdiction clause, you need to show cause of action, you need to also have prayer towards the end of the preposition. And this was my first courtroom exercise experience. And so I wrote the whole preposition, but I wasn't aware of the prayer clause. So in my memo, I did not have the prayer clause. And after making my submissions before the professor asked me to come to the prayer clause, and I said, "What is that?" I have never prayed. I have never thought that there could be a prayer that you have to seek a relief. And then she was kind enough, said, "Subhash, it seems that you do not have a prayer clause. Let me help you." And she recited the whole prayer clause, like, in the view of facts and circumstances, it is humbly prayed, XYZ. This is, I'm telling you, in 2004 when I joined the law school. We are in 2025. So far, past 21 years, I have ensured that whenever I start my submissions, whenever I start my plaint or any interim application or anything, the first thing that I look, and the last thing also that I give the most consideration, is the prayer clause. So every day since 2004 till today, and definitely in future, every day is a learning process. We all are learners, be it in law school or in practice. And not just learn law. Law is something which binds the society. Law is something which regulates, which is the most constructive part of society. Everything that we do, while we are having a podcast, we are creating something. While we are having water, we are looking at brands, we are looking at food safety licenses. Everything is part of law, right? So you need to learn anything and everything in your life. Why you're drinking from why it is called a packaged water and not a mineral water.
Right.
You should question everything. The inquisitiveness is the most important aspect of legal practice.
Right.
So that's how I'm in law, and I prefer being a lawyer. It's a very rewarding profession. In my journey of past 16 years in the practice, I have met amazing people, amazing clients, seniors who have taught a lot, who have trained me a lot, and something that I would want to contribute to the society through such podcast.
Thanks, Subhas. Subhas, just a follow-up question. Are you a first-generation lawyer?
I am a first generation lawyer.
Then I'm interested how from Mirzapur, your first internship, and how it shaped your interest into IPR and art law. If you can take us through that primary journey.
Yeah, so in law school, I think the first internship was we were required to go to an NGO.
Right.
And Calcutta, because it's like a second home for me. So I went to Calcutta, and I was interning with this organization, and it was at parallel to Park Street. And every day when I used to cross that area, Calcutta is a very warm and very artsy place, right?
Definitely.
It has a lot of history, a lot of art, a lot of culture, and that's how I've always been interested towards the creative things. So that is where I realized that there is a scope of uh, practicing law within the ambit of or probably to help out these creative fields, creative professionals. Gradually, of course, it was a very nascent stage. It never occurred that way. During law school, I picked up guitaring. So
Okay.
again, came back to the roots of being a little more creative. And when I came in the practice, I got to work with musicians, with production houses, with artists, um, and that's how the interest kept growing to better facilitate the process of law in this industry. In 2017, when we started Crida Legal's IP and art law practice, it was more closely associated with art law. And I realized that it's a very unorganized sector with a lot of misinformation. People don't understand the difference between designs, copyright. That is one part of it. But contracts, insurance, recoveries, there are so many other issues which are part of art law. We've been doing a lot of activity towards the criminal side of art law, like forensics are involved, provenance is involved. Uh, Whenever we go to hotels, we see a lot of artwork. Almost every room would have an artwork.
Definitely.
The concierge has an artwork. You would go to ITCs of the world, you would see a lot of nice murals around. In fact, so interestingly, like when COVID happened, a lot of people wanted their background to have nice, beautiful works, right?
Right.
So there was a lot of purchase of art. All this as a composite practice, as a multidisciplinary practice, becomes art law. And that is what we started growing. So when we started with Art Law India, you have seen the blogs.
Yes,
The
definitely.
blogs are not written in a very legal manner. They do not have legal jargons. The idea is to make people aware of law as part of the art industry. And that is why when you read about, say, the movie, that Gulabo Sitabu movie,
Yes.
or about the tattoo art and
Ink
all those,
tattoo, yeah.
right?
I was reading that
Yeah.
article.
All of it is written in such a manner that people understand that even this industry has a lot of laws involved,
Right,
and we need to be more aware of it,
right.
right?
So, coming to next segment, Subhas. Most law students know corporate law, criminal law, civil law, but art law sounds niche, exciting. So, how would you explain art law to a fresher, to a law student?
Correct. So, see, just like, so when we are in law school, we are taught law as a theory, as jurisprudence, as a standard, in books and bare acts, in commentaries.
Right,
We are not taught law as practice areas,
Right.
in practice verticals.
right,
You are a corporate lawyer yourself. You would understand that you create a niche in respect to a specific sort of business domain,
right,
right? You may be known for your pharmaceutical practice.
Exactly.
You may be known for your sports and gaming practice.
Right.
All these verticals, we are sitting in a studio.
Right.
This is part of media and entertainment.
Right.
It's a vertical in itself.
Right.
Right. Now, these verticals are multidisciplinary verticals. It will have anything from employment to labor to personal injury to consumer to media entertainment, as in to copyrights, to several different laws would function together in that vertical. Now, when we thought of art law as a practice, we thought, and rather we developed this multidisciplinary practice, which includes from it includes taxation law, a lot of customs involved, excise is involved, because you purchase a lot of artwork from outside or you export artwork. A lot of logistics are involved, and when logistics are involved, insurance is involved. The nail to nail insurance is involved. When somebody is purchasing art for private collection or for museums or for any other purpose, then issue of genuinity, authenticity are involved. When there is volume purchase by hotels and hospitality, then consignment agreements are involved. When you want your house to look beautiful and you want an artist to do mural, you have been to Lodi district,
Yes.
Lodi art district, and even in Bombay, Start is there. uh, when you put mural, it's a public art.
Right.
Now, what is the law on public art? What do you do with graffitis?
Right.
So it's a multidisciplinary domain which involves people from in every practice area. So even if you're a corporate lawyer, you can practice art law.
Okay.
Even if you are a tax lawyer or you have tax expertise, you can practice art law. Even if you are a IP, of course, you can practice art law. So art law is not restricted to IP lawyers, as
Right.
it is generally construed that it is because it is art, it has to be IP.
Right.
IP is just about 25-30% of the art law practice.
Understood. So, coming to next segment, what does a typical art law lawyer's day look like? Are you drafting mostly contract, negotiating deals, dealing with disputes? So I will broaden it like art law and a IP lawyer. I understand you said that it is a comprehensive,
Yeah.
not very niche. But generally, as your practice in art law, what is a typical day look like?
See, it's very interesting working with artists, galleries, because they have a different mindset.
Right.
For them, probably they are not aligned to understand law, and they have their own visions. They have their own temperament. So, as a art lawyer, not as a lawyer, as an art lawyer or as an IP lawyer, I first of all try to understand what is that they are trying to, tell, what they are trying to, what they are suggesting, what they are uh, trying to share. So many times I don't talk like lawyer at all.
Right.
I cannot, because the moment I speak my language, they will be in doubt whether they should do something or not. A very recent example is I'm helping a client with certain copyrights, and it's a very interesting aspect because artistic style is not something copyrightable. We saw Studio Ghibli issue,
Right.
and something which is not protected per se. Either it can be a part of your personality, but again, what happens if once you expire, once you pass away, then that part of personality right is gone,
Right.
right? Then after posthumously, if somebody copies your artistic style, how that can be protected,
Right.
right? So there are issues. So when this artist, she wants to protect her artistic style because in that style she has made thousands of artworks.
Right.
She would not want to spend so much on copywriting each of the artwork. But as an art lawyer, as someone who understands artist's temperament,
Right.
someone who understands art, and
Yes.
someone who understands law,
Right.
I recommended her that let's do it in this way, in certain way, so that you can protect your artistic style to certain extent.
Right.
If not to the largest extent or to utmost extent, at least it will show to the world that this is how you have created your style.
Right.
And this is something very, very crucial because the copyright law does not, it only, it only probably protects the expression, right?
Right.
Artistic style can be in any expression, it can be in any media. So when we talk to artists, we also ask them about what media you use. Are you on acrylic on canvas? Are you metallurgy? Are you into ceramics or pop? So you need to become an artist
Right.
to become an art lawyer. You cannot remain a lawyer and say that okay, somebody will come on my desk and then we will discuss the issue. There are no issues.
So it's
Yeah.
like holistic perspective.
It has to be.
Yeah, definitely. So, in your experience, where do artists in India most often lose out? Contracts, copyright, registration, or enforcement?
See, it's a mixed thing. Largely, see, I won't say lose out, but it is because this domain is flooded with misinformation, as I said, or lack of information or lack of awareness.
Right.
When we talk about corporate houses, there are KRAs set, there are SOPs set, there are ERPs in place. But industries like fashion industry or art industry, they are very unorganized.
Right.
They work with craftsmen, they work with artisans, they work with karigars. All these are mostly freelancers,
Right.
dihadi workers.
Right.
And they are the one who are creating for you,
Right.
right? But then there are designers who have sort of given the wireframe, the blueprint of things. So the industry it is the misinformation because of which there are issues. Now, we were doing certain contracts where the gallery wanted artists to stay represented with the gallery for 4 years, and all the artworks will only be procured by the gallery for further exhibition through other museums and galleries.
Right.
So it was supposed to be an exclusive arrangement. The artist did not understand the exclusive arrangement. An issue arose. An artist said that I want to go away from you and want to exhibit with some other gallery. The gallery said no. There's a lock-in for 3 years, 4 years. So this is because the artist could never understand the term exclusivity.
Okay.
It's as simple. One single term changed the whole scenario. Because from non-exclusive arrangement, it became an exclusive arrangement. The artist got stuck. So what do they do? Right? So this is very important for galleries, for artists to understand. The issues arise because it's a commercial transaction at the end of the day. We all need to understand. So the issue arises because of absence of contracts, because of absence of arrangement. They don't even understand a single email can be a good contract.
Right.
A single WhatsApp message can be a good contract, right? Provided you want to treat it as a contract. So these are the things that are lacking, because of which the issues arise. But as art lawyers, as a practitioner, we always endeavor to to make them aware of things, to facilitate expeditious resolution of issues, because that is not what they want. Nobody wants
Right.
disputes. But when dispute arises, people want it to be resolved expeditiously in the right manner,
Agreed.
right?
Yeah. So, little while ago, you were talking about difficulties related to copyright of an art, or like how the personality can be preserved. So, do you think Indian law adequately protects moral rights, like the right to be credited or to preserve integrity of their work?
Yes, absolutely. I think the Copyright Act 1957. So, it's interesting. From 1957, we have a very, very robust, very well defined law.
Right.
And it recognizes almost every kind of art.
Right.
And there are certain provisions which are very specific to India, like resale royalty, something which is available to almost everyone except photographers, but nobody claims the resale royalty rights,
Okay.
Drodh as we call it. So that is something very interesting. Moral rights are very robust, and there are several judgments on moral rights from Amarnath Sehgal to Jatin Das to Raj Raval. There are several judgments which uh, discuss the issue of author's special right or moral rights or right against mutilation, right of attribution at extent. They discuss in detail, and you have jurisprudence, you have law, which helps you. It is at the end of the day how you enforce. Like there are several times that you have done certain commissioned work, you have done murals, you have done acrylic on canvas, and your name is not, uh, you know, provided, or it is not you. The credit is not given to you. You don't know what to do. Like recently, I was talking to a poet, and it was quite controversial. He went social about the whole aspect of his shairi, which was during the one of the protest, which became very popular, and he wanted to take some action against the artist who used those proses or that shairi for the artwork she developed, which was exhibited with the gallery.
Right.
So we spoke at length, and he was more, irked by the fact that the credit was not given to him.
Okay.
So artists are very sentimental people. We need to understand it is not just about money; it is about the credit. So moral rights for artists is very, very important, and we are very fortunate in India to have a Copyright Act which well defines the moral rights and protect it as much.
Okay.
So yeah.
Taking cue from Ghibli that you mentioned, we all have swept under the wave of Ghibli art. So, just an interesting question with AI generated art, who should be considered the author? The programmer, the AI tool, or the user who prompted it?
See, it's again, we are in a very different world.
Right.
Um, the new world, I would say, does not have laws which adequately answers all the questions.
Right.
The courts are trying to answer this question. So far, it has been played safe to say that if it's a computer generated work, and that is what even our 1957 Act says, which was, of course, amended when the IT revolution came. The computer generated work, in case of a computer generated work, the author is the person who has developed that computer program,
Right.
So if I go by that fundamental definition of a computer generated work, who is the author, then whoever is the developer, so OpenAI is a developer, say for example, then they are the author, to say, right? But the question has several, paradigms here, because there's so many times that you do not want to copy someone,
Right.
but the computer has created a copy or replica or a work which is substantially imitating an existing valid copyrighted subject work. Then whether the person who has developed that computer program, whether that person would want to take the liability of that creation is a question. Now, the courts, even the US courts and the Indian courts, the ANI, proceedings which are going on, they all are trying to not just make the developer liable, but also trying to understand whether there can be a fundamental understanding on the authorship and the ownership. So,
Okay.
copyright law distinguishes between author and the owner. right? So author can be, say, anyone,
Right.
but author has to be a human person.
Right.
We had that chimpanzee case, Naruto case. So the courts have always taken a view that author cannot be anything other than human.
Right.
Owner can be any legal person, a company or a human, right? Within this ambit, anything which is created, if it has a human author or if it has a legal owner, that can be protected.
Okay.
One thing very important to understand is not everything is protected.
Right.
Copyright law will only protect what is original work, which is created by a human author, which is owned by a legal person.
Right.
If it is something which is beyond this definition, it will not fall under the ambit of copyright law.
Okay.
But if somebody has to be made liable, is the question before the courts today. And how can they be made liable? So that is the issue.
Okay. While we understood the role of contracts and other aspect of it, now I would like to understand little about art disputes and arbitration. So my first question would be around how is evidence handled differently in, say, art arbitration, especially when dealing with forgeries or, say, cultural heritage claims.
Yes. So, see, largely and fundamentally, it is about finding whether the work is authentic, what is the provenance of the work, whether they have enough evidence to show that the work was part of the private collection, it was gifted by someone, an artist, and it was part of a private collection, and then it came into part of the succession, and then it came to exhibition or whatever through an auction sale. So that bit is important. Now, when we talk about arbitration in art industry, it is very important because art industry works, well within closed doors. It is not something which is very exposed to the world. How the galleries do their transactions, how the artists get paid, what is the value of an artwork. These are very, very sort of secretive things, and that is why a lot of times the art community, they don't want to come to court. They don't want to be exposed to certain, because the moment you are in due process, you're part of due process, there are issues, there are aspects like interrogatories and discoveries and production of documents. So you have several weaponry and armory to find out the right information, right? So in that is why it is so important to have the ADRs, and ADRs becomes the most amazing conducive tools to resolve disputes in art industry. When I talk about arbitration again, it's almost like a court proceeding, but with your own set of rules and regulations. And when it comes to arbitration where it relates to purchase of, say, artworks, and suddenly it was found that the artwork is not authentic, then you would require people like art curators or art historians to come as an expert to tell that whether that art is genuine or not. So I'm part of Court of Arbitration for Art,
Right.
and they have specific provisions for having experts who can provide evidence or their testimony or affidavit of the provenance of the authenticity of the artwork, and this is something which is very specific or very interesting in art arbitration. Something which generally lacks in regular commercial arbitrations. You don't call experts to testify that whether this should proceed or not. So if you have a preliminary issue regarding the authenticity, so first of all you would want to identify whether the work is authentic or not.
Right.
Whether that work has come with a direct, it's like any asset, it's like any property, you need to see the chain of title.
Right.
So if as a preliminary issue it is defined that there is no proper provenance or the work is not authentic, then your other issues with regard to recoveries or breach of contract, XYZ things, they all will be infructuous. So that is where probably in India we do not have such a setup. We have a volume of art curators, art historians, universities who can be the center for such experts. And that is a huge opportunity for everyone in the art industry to explore these art arbitration centers. How we can, sort of create that community around. So, yeah.
Leveraging on your 2 decades of experience, do you see scope for India to develop specialized art arbitration forums?
Yes, absolutely. That is what I'm inclined to see. I'm rather hopeful to see that the industry, the community, the organizations as part of the industry, they should come forward, and there should be a set of rules and regulations, maybe based on what we have at CAFA, the Court of Arbitration for Art, something that we can develop in India. And because the industry is huge, and it is pan India
Right.
and even abroad.
Right.
We have artists who are now settled in Dubai, in the US, in several countries. There's a lot of transactions happening across the border.
Right.
In such cases, you don't want to restrict yourself to jurisdiction of courts, and you cannot simply say who is a competent court, because we all know from the practice that uh, the kind of dispute that arises in art industry, they may not be appreciated well enough through district courts in somewhere in remote areas of India. When you have such arbitration centers, and when they have the right set of rules and regulations, when they have panel of arbitrators or mediators or neutrals as we call them, then it becomes easier for people to resolve their dispute. It'll facilitate the process of dispute resolution. The disputes are always there. As I always say, whenever there are two people, there has to be a lawyer around.
Right.
Disputes can't stop.
Definitely.
Right? So this industry also has a lot of dispute, and there's a lot of opportunity for arbitration. That's why we need to create a better set of lawyers who can practice art arbitration. In fact, I have been, talking to all these universities and their cultural committees, because these are people who are more inclined towards art.
Right.
So what I have realized, from my experience, that you need to be a better artist, or you need to be an artist before you become a better lawyer.
Definitely.
Right. So people who are part of cultural committee, and generally who joins cultural committee, I was part of it. So I'm like, like the Chetan Bhagat, we have these, what novel was it? 5.7?
Yeah.
Right. So, so we all are like people who generally are not part of the creamy layer. I'm not discouraging anyone, but I'm saying that people who have a different bend
Right. Right.
in their life, and they still want to be better lawyers, they should pursue, and they should definitely consider niche areas like art, like fashion, like sports,
Yeah.
and there's several other areas of law which you can identify and explore. So it's
Sure.
easy.
Since we are talking about dispute, I will take a step back and want to understand, you have judged moods like Jessup, Stetson. What do you actually look in the students, the research, the depth, the advocacy style? What do you actually look when you judge these competitions?
See, I think most importantly, what I have in my experience also, I find that fundamentals are most important.
Right.
We generally have a habit of jumping the guns and coming directly to the to the law. There are times when the facts are very clear.
Right.
You just have to understand that what is the fundamental law applicable on that
Right.
fact. uh, I was judging one, I think it was a private international moot court competition, and they were all haywire. They were
Right.
going into different uh, international conventions. They were talking about XYZ things, but the preposition also at the core of the preposition was something which was very fundamental, and that none of the memos, none of the arguments or submissions, nobody ever mentioned that bit. And I was quite curious to know why nobody touched upon that aspect, which is so fundamental. So the habit of trying to be fancy instead of fundamental is wrong.
Right.
So whenever you start with any proposition, and just apply your mind that you have done contract, the most fundamental of the law, contract and constitution. Whether any proposition, does it have constitutional issue or a contractual issue? Where then you go the step ahead, then you go into sales of good, or you go into transfer of property if it's more on the contractual side. Then you get into the company's law, but that is a subsequent step.
Right.
The first step is whether constitutionally it is correct, whether by CPC it is correct, whether by contract it is correct.
Right.
And whenever I'm judging the moot court, I am surprised, and it's literally shocking at times that my questions stick to fundamental of things and nobody has answers to it.
Like maintainability.
Because yes, maintainability, jurisdiction, why you have implemented this person as a party,
exactly.
why you have not sought a cause of action in respect to this bit. They all want to discuss only because generally what happens, I have also been a law student. I can say from my experience that whenever we get a proposition, we try to find the most similar cases based on which the proposition has been created.
Exactly.
And then we identify, IT law was mentioned or something like that. So we just read the IT law.
Right.
We don't come back and see whether there was a criminality involved, whether there was a personality right issue involved, whether there was a breach of trust involved, XYZ things. So we don't come back to IPC. We stick to IT law.
Understood.
Right. So these are issues, and I think that is the most fundamental, because your footnotes doesn't matter.
Right.
Your etiquettes of indeed your lordship does not matter.
If it may please the court.
Yeah, that does not matter. What
Exactly.
matters is that how can you convince me on the law?
Right. So it struck me while you are communicating with these cultural committees of various law school, one way to encourage students to get into art law may be a moot around it.
Yeah, absolutely.
Researching,
Absolutely.
maybe they will be able to explore that portion, and they never know, they
Yeah, we
discover
should.
something which is they are fond
Absolutely.
of.
An arbitration on art, that could be a very good
Starters.
way to start.
Yeah.
Absolutely.
Also, since that is not around right now, if you were to advise these young law students, if they wish to enter in your field like art law, IPR, how should they go about writing research papers, internships? So if you can lay down certain points which can guide them to enter into this field if they wish to.
So there are several aspects to it. A, of course, you need to be very well prepared with IP,
Yeah.
especially copyright laws, and not just domestic copyright laws, but international copyright laws, especially US. You have DMCA, you have, there's a specific law for public art. VARA also is there, Visual Art Representation Act. You need to understand these laws very well. B, you need to network a lot.
Okay.
Networking is very important, and networking because everyone either purchase or sell art. We all do. We appreciate art. We go to museums, we go to exhibitions, we go to India Art Fair, we go to Craft Week, all those places. You have to network because it's a very niche practice area. You cannot just jump into this area and start churning out work and money.
Right.
You need to start networking from day one.
Right.
Need to create your own community. A lot of HNIs have private collections.
Right.
You need to help them. You can work or intern with their family offices,
Right.
so that you can help them with succession plans.
Okay.
You can help them with valuation of artworks.
Right.
You can help them understand what if you want to exhibit your artworks, what could be the ticket terms and condition for the tickets, and all those exhibitions. So this is how you develop your practice in art industry.
Right.
You need to write, and you need to be aware of what is happening in the art industry across issues like public art. Still, it is very nascent in India. We do not appreciate public art as much.
Right.
Metro pillars have been beautifully painted, and then you will suddenly see 100 rupees mein internet lagwaye. There are all these pamphlets on the metro. So people don't appreciate. So first thing is that you create a community.
Yeah.
You have lawyers make people aware of or respect art, to give proper regard to the artist.
Right.
All these artisans who have come across India to paint these metro pillars, they need to be regarded. They need to be credited. So once you start developing that temperament, then you would become a better art practitioner.
Right.
That is the first level. Whenever you are interning, see if there is an opportunity for you to also work on things which has art. Like I mentioned, family offices, uh, if you are working with a firm and they have hotel industry as their clientele or hospitality industry as their clientele, they would purchase a lot of artwork.
Right.
See if you can, propose them some ideas, right? So you have to be a little more observant.
Right.
You
Exactly.
have to keep art in your mind all the time. Only then you can come across and become a better art lawyer.
Understood. So, what I just gauged from what you have just said, HNIs, right, hotels, these are very different industries, right? Like, in order to enter into that, so say if someone wants to intern with an HNI who has great art collection, and you are the in-house counsel for them, what would you look for in an intern or in a say fresher? What would you prefer in that
So, couple of things. Of course, you can create a repository.
repository?
You can help them understand how to create a catalog of what they have collected.
Okay,
Now, certain artworks are purchased.
right,
Certain of them are part of your legacy.
right,
Few of them have been gifted because
right,
you are friends with artists.
right,
All these require legal documents.
right,
There has to be a succession, a will, or testamentary something document. If it is self-acquired, you need to have invoices in
right,
some way or the other. If it is gifted, you need to have a gift deed,
right,
right?
right.
So you create a dossier, you create a proper docket of all these different documents for each of the artwork. So tomorrow, when you want to will these artworks,
Yeah,
you have everything in place,
right.
right? So yeah, this is where you can start working.
So basically, creating a repository that what kind of agreements or say what
Yes.
kind of legal documents that are involved
Yes.
in establishing the ownership, transferring, and then transferring those ownership
Yes.
basically. So for a starters, we can go through that
So
and
all the law students, they should be very well aware of the family laws,
right,
of the
exactly,
contracts,
right,
because these are laws which generally we don't want to even read during
right.
law schools, right? Family law, it's so boring, but it's not boring when you look at from this
That
perspective.
perspective, yeah. So that's what I wanted to deduce from these
Yeah.
freshers that family law will be a great start. Then
Yeah.
contract law will generally help in all the
Yeah.
possibilities of legal domain which they want to venture
Yeah.
out. Thanks for this. Now coming to little, I want to understand the future outlook in this field. So should India develop a specialized legal framework for cultural property? Restitution of looted art has been a contentious issue, so similar to international conventions.
Well, we have enough laws.
Okay.
It is about implementation, it is
Okay.
about enforcement.
Correct.
Uh, the laws have been there for several decades now.
Right.
Restitution is something which is largely a diplomatic discourse,
Right.
negotiations at a higher level, and that is, of course, as lawyers, we always facilitate.
Right.
While we may not be the person who would be having this negotiation of,
Right.
but we can always, through our documentation, through our research,
Right.
we can facilitate a restitution aspect. Uh, there is a lot of scope in the cultural industry.
Right.
We have several GIs,
Right.
but we have a lot of folk art which is still not recognized as GI.
Okay.
We have seen recently there's several issues,
Kolhapuri chappal.
Kolhapuri Krishna Dior, and in fact, sometime back, again a dire issue was with People Tree,
Right.
Arijit Sen. So we also spoke, and there is a lot of this drain of Indian art and culture which is not protected because cultural property is public domain.
Right.
It is not exclusive to any individual, it is part of the community. We do have GI laws, but that only are restricted uh, to certain identified artworks or artist styles or art styles. In fact, there are so many loopholes in GI itself. Like recently, we were doing the Kolhapuri bit also. We were writing a note on it,
Okay.
and we realized that the GI filed for Kolhapuri is by a public limited company, while the GI laws only allow association of person. So if somebody wants to question, they can even question the maintainability of that GI registration.
Exactly. Not
Right.
permissible under law. Basically.
Not permissible. So, you know how it is happening because of the lack of understanding of law, and the authorities need to be better trained. They need to be sensitized. We need to sensitize almost everyone in India to appreciate art, to appreciate culture. Only then they will realize that just making hue and cry about somebody copying a kolhapuri does not make us, the owner or the proprietor of that culture. How many of us wear kolhapuri?
Barely anyone.
Barely.
Right.
But we raised hue and cry
Right.
because somebody showed something which is similar to kolhapuri.
Right. Definitely.
Right.
Yeah.
So this is what we lack is that temperament to appreciate art and culture. That is very important to develop.
Right. So, with generative AI coming to picture, a lot of arts being developed. How do you see this practice growing on art law IP? Do you still see it as a niche area, or you see it coming as a mainstream area where you will see more dispute, more people hiring lawyers for protection, transfer of ownership, having clear title basically?
See, it is continuing. It is, as I see, it is not something which is very developed.
Right.
Most of the galleries or artists, they would try to resolve the disputes inter se. They don't want involvement of lawyers.
Right.
We all are very scared of law,
Right.
and for them, lawyers are even scarier,
Right.
right? So they would want to resolve things more through equity rather than law. So when we talk about justice, equity, and good conscience, the justice is sort of missing. Equity is the major factor how they resolve disputes.
Right.
There are, in every industry, not just in art industry, but in every industry, be it publication, be it IT, everywhere, generative AI is coming in. The
Right.
LLMs are developing every single day.
Right.
We as lawyers, we as law firm, we also use a lot of AI.
Right.
We are a paperless office, and
Right.
everything is, in the sense of IT.
Right.
We are developing our AI LLM so that it better helps us.
Right.
In industry like art, and especially printmaking is
Right.
one form of art, or where the digital print making is involved, AI would be replacing a lot of artists.
Right.
So while the industry itself is going through certain transition, and not just art industry, every other industry, because of the different LLMs and GPTs we have, the AIs, it is important for us to not just identify what are the disputes arising, because probably today they are dispute, the moment they are made a law, there's no dispute,
Dispute. Yes.
right? How it happened with the gaming industry, say
Right.
for example. So we should be more wary of the fact that the transition, or we should envision how the future would be after this transition.
Right.
And as lawyers, we are we can foresee the future because we have learned so thoughtfully, so deeply, that we can foresee what is going to be the future causes of action.
Right.
So after 5 years, people who have just entered law school,
Right.
they need to understand that whatever is happening today is not going to be the dispute tomorrow.
Tomorrow. Right.
So after 5 years, like how IPC changed into BNS, how after 5 years, which law would be created to dispose of all these disputes, right? And what would be the disputes in future? So one should be, and especially law schools, should build this temperament of, futuristic lawyers, or they should understand that in 2 years, 3 years, 5 years, the generation and the practices will completely change.
Right.
There'll be lesser service providers. They'll be more into manufacturing. So they need to understand this,
Right.
right? So the inclination should be to understand how do you protect cultural property, because that is going to be after 5 years, I see that cultural property will be very robust, because all these digital printmaking, the artworks which are not uh, which are created or computer generated, they will lose their uh, you know that what do you call it, as a relevance, right? So they'll not be relevant at all.
Right.
So something that can be seen today itself.
Right. Suppose if I were to pick your brain and say, what is one policy or rule that you want government to build in or to bring right away to have like a better control on some issue which you think during your practice that needs to be resolved, or government may step in to have a like a better future without any dispute? Anything you can think of like in this practice
See,
area?
provided government has a very balanced view about things,
Yeah.
because generally we don't expect uh, see, that is why we have separation of powers.
Right.
We have to do the check and balances. And while I reserve my sort of comments on this aspect,
Yeah.
contextually it is very important that people should be made aware of art and cultural property,
Right.
and irrespective of what and from where it comes, it should be treated as it should be a harmonious system. It should be more inclusive system, and that will generate a temperament of admiration, of appreciation of art and cultural property. That is the first and foremost thing. Once the government works on this aspect, then you can go ahead and have organized system of commercializing, monetizing, resolving, all these things. And I must appreciate in past several years uh, that a lot of public art has come up.
Right.
We see KNMA's Kiranada Museum of Art doing all you know uh, these roads and walls on the street walls. So people are appreciating, but I see it only in metros.
Right.
What is happening in the tier 2, tier 3 cities or towns and villages? Is that temperament also developing there? While they are the one who are actually the guardians of our cultural property.
Right.
I don't see artisans in Delhi, but I would definitely see artisans in Madhya Pradesh, in some tribe areas, or in Rajasthan, these folk artists like Manganyas. So, what are we doing to ensure that they are also included in this system,
Right.
which is missing? So, yeah.
I think this is picking up. So I hail from Bihar, right? Madhubani painting.
Oh,
So has been heart of Bihar,
Yeah.
and now on all the railway stations,
Yeah.
we see these paintings, but we never see those artists
Yes.
who have drawn it.
Yes.
What a tremendous work! It's so peaceful when you see
Yes.
those stations, but unfortunately, never get to see those amazing artists
Yeah.
who have draws those fine lines. But okay, moving to next segment. This will be a little personal and fun. Apart from law, basically, we will be checking on your personal interest. So, I got to know that you picked up guitar in your third year, right? But have you ever considered becoming an artist yourself before choosing law?
To see, art is something which is inherent to everyone.
Right.
You don't generally pick a career because, see, you what you're good at, you would only do that, right?
Right.
I understand art, I appreciate art, but probably I don't understand the process of layering, the using of spatulas, all those things. And probably I don't have that patience to even become
Exactly.
that kind of an artist. I think it is better off that I'm a lawyer, because then I get to see everything.
Right.
I work not I I've been representing not just the artists but fashion industry, but FMCGs to pharmaceuticals. So I get to see everything, and that is how I prefer. Good to be a lawyer.
Okay. I will still bother you on that. If you weren't a lawyer, what profession would you be in?
Maybe a court clerk.
Something legal, definitely.
Yeah, I think I've developed my DNA like that.
Okay.
Yeah.
something most unusual or bizarre that you have come across in terms of art dispute that may sound straight out of a Netflix series?
Uh, Interesting. So we were doing this copyright infringement matter, and so this artist has trained several interns,
Okay.
and he's an sculpture artist, a
Right.
sculptor, and one of the interns, she understood the whole idea of how to make the cast and dyes and cast. She got in touch with a person who makes the dye and cast, and she got the same sculpture made from that um, person. And while my client or our client used to sell those structures at a very high price, this intern saw an opportunity to monetize. She was selling at almost 10% of the price. In fact, it was very interesting. While I was in Ahmedabad some time back, and I saw one of the hoardings with this artist sculpture, and I was so happy to see, because as lawyers we are always very enthusiastic. It's a lot of excitement when we see our clients somewhere. So I saw that structure somewhere, and it was very nice to see that. So when we went to the court, before that it was very important, and I realized long time back when I was a kid and my dad was fighting a matter, and he used the geometry, we used these compass, and so we did the same thing. We tried to compare our original artwork with the copied artwork, and we used the compass and those
The measurements,
measurement
basically.
protectors and all,
Yes.
to show that each element of the two artworks
Are identical.
are identical and they are of the same dimension.
Right.
So it became a strong prima facie case. It's an ex facie case. And that is how you show to the court that, look, she had copied ad verbatim my work. So there is no opportunity for the other person to say that, look, I did it in a different way. Because the moment you show that you only got inspired and not replicated something, that is not infringement, but it was shown beyond any doubt. So summarily, it was decided, and the matter got settled, and the client was happy. And so many other, very interesting aspects happened. We were doing this transaction where somebody wanted a mural to be painted on the wall, and so they engaged with a gallery for doing that work, that piece. And the gallery, of course, they came to the artist for doing that piece, the mural, and it was a commission agreement. And the person who wanted the mural to be done, uh, that person wanted the artist also to be part of the agreement, to indemnify that if something goes wrong with the wall or something goes wrong with the house because of that mural, then that person will be made liable. And the artist was sort of
Baffled with all
not
this.
just baffled, he was agitated, because when I spoke with him, he said, I cannot work.
Under
I said,
pressure.
why? He said, my creativity will always be under pressure. I cannot work. I cannot create that mural out of my creativity because I've signed onto certain paper.
Right.
So I said, this is very interesting. How to go about it? How to, So we made certain changes. We did in a manner that if something goes wrong, then somebody will take care of it. The artist will not be part of this thing. There is no privity in such contract. So it went through, and the artist was also happy, and hopefully the mural would not cause any destruction to the house. But yeah, so there are very interesting things, because the facts can come from any way.
Right.
You really don't know what, and that is why while we are reading judgments, we we read the obiters.
Right.
We are taught to read the obiters, or we are taught to read the decision, but we are not taught to read the facts. The first thing that I always notice in a judgment whenever I am reading a case law is who is the judge,
Okay.
who had appeared.
Right.
In fact, we were doing a negotiation where we were citing a judgment. We were just showing to the other side that look, there is a judgment on this aspect, and this judgment, who has appeared, who has got this order, who has got this determination, it's the person who is representing you right now. So it is so important.
Puts them in a pickle.
Yeah, so it's so important to read everything in a judgment, especially who is the judge and who are the lawyers who have represented each side.
Right. Since we are talking about nuances of law, I understand client management is also very central aspect to any law profession because we work around people. So how a artist client different from a normal client?
Oh, very different. Very different. They, as I said, they are very sentimental.
Right.
You have to be very good and a patient listener.
Right.
They will talk at length. They are not like a regular corporate client, not a GC, not a one-liner email, as we just do it. They would want to pick up call at 1 o'clock in the night. And they will say, look, SB, I just want to talk to you. And you know that it is going to be the morning. So we've worked with musicians in Bollywood, and we've worked with artists. They would call you late night and they will want to speak to you at length. You have to be a very patient listener. You do not jump the guns. You do not interject them. Let them talk. Once they're done talking, then all they want is a sort of assurance that yes, this can be taken care of. They don't want to know law. Law is
Right.
something that you will practice.
Right.
They just want an assurance that whether you can do it or not, whether it is something that can be done or not. So if you are able to do that kind of talking, if you are able to give that kind of conducive environment for someone to sort of concede, that is where you become a better, preferred lawyer rather. So yeah.
So I think you do high stake cases. So which everyday habit or quirks that keep you grounded despite these high stake cases?
So for us, all cases are high stakes and all stakes are high ever.
Right.
So see, what is very important is that we maintain a very positive environment
Right.
across our every member in the team and in general. So what we have understood, and at least I have understood before starting Law SB, in firms, what are the main causes because of which there is this term toxicity
Right.
starts, right? It is because there is a hierarchy involved. Hierarchy leads to hostility, uh, unorganized manner of working, lack of time management, giving that space to people. So what we did, the first thing that I did was to start a paperless democratic office.
Right.
We do not follow hierarchy. Everyone's a colleague. We are just known as seniors or juniors because of our experience, and that's
Understood.
about it. We do not have a culture of sir and ma'ams.
Right.
So why this is important is because every day you're spending about 12 to 14 hours in your office.
Right.
If you don't create that kind of environment,
Right.
the people will not work through their mind. They will work under pressure.
Right.
We want people to deliver quality. It's not about deadlines. Everyone has to meet deadlines. We all do. But why to create pressure of meeting deadlines? Let's focus on creating quality deliverables within the deadlines,
Right.
right? So it is very important for us to have that positive environment in the office. We have kept it, again, whether it's a staff, whether it's a lawyer, we all are treated the same way.
Right.
And that has helped us stay grounded because we do not have an office boy
Right.
that he will bring the coffee.
Definitely.
You need coffee, you go get your coffee yourself.
Right.
So even if you're doing the high stake work, whatever work that you're doing, your humane nature, your humility has to remain intact. And that is why if you go to Law SB's website, the first thing that we write is about human values.
Right.
It is all about how, because we are an HR industry,
Right.
we need to understand legal practice is an HR industry.
Right.
you deal with more human than any other
Any
person,
industry, yeah.
right? So if you're not humane, if you don't understand humility, if you don't understand these temperaments, probably you cannot work. We have set up a paperless office. Why? Because we want people to work at ease,
Right.
not at any time, but
Right.
work at ease. So we don't want people to come during peak hours. Why to waste your 2-3 hours in traffic?
Traffic, yes.
You start your day early or whenever you want to. You finish the work.
Yeah, right.
And trust me, God has been kind that my team is available 24/7. Whenever I tell them or ask them to do something, and they happily would do it. They will not crib about it. If they have some issue, somebody else would do it. But they will also say they will delegate work or they will share the work. That is the kind of system that we have built and has helped us skim through any stake matter. We have got best of the orders from the court. Uh, we've been helping clients at any given point of time, and that is where you build your trust with the client.
Right.
Most of my clients are dear friends. I'm their SOS. They would also pick up call and say, SB, kya karna hai? They just want to talk at times. They'll say, SB, I was just missing you. So there are times when you would, and that is what you build. As lawyers, you build a community. You don't just build legacies,
Right.
right? That is important.
I think if we start treating human as human, I think we'll be able to
Absolutely.
solve most of the problem. I think I will take just one last question and then I will let you go. I have taken almost a lot of time. So, what is one unpopular opinion that you hold about, say, law or art that might surprise people?
Unpopular opinion.
Yes, I said it is a little personal and fun session we are doing. So, we can't let you go without this.
I know. I think we should not be treated as liars. I think
Is it unpopular?
it's quite popularly infamous to
Right.
say. I think as a lawyer for all these years, we need to make people aware of our presence
Right.
in the right manner.
Right.
People should not treat us or should not see us as somebody who is only going to benefit from you.
Right.
As I said, human values are very important.
Right.
So what needs to be popularized is that you should first go to lawyer and then do your work.
Right.
Now most of the clients that we work with, they have understood our SOP.
Right.
SB, I want to start a new brand. What is coming to your mind? XYZ. Let me check if X is available or Y is available or Z is available.
Right.
So now it is that fear of a lawyer, of courts, is vitiated. It's somewhere, diluted.
Right.
They don't fear because they have us.
Right.
To every law student, to every lawyer, it is very important that you start from your own family, start from your relatives, and dilute this fear
Right.
of going to lawyers. We don't delay things in court. Most of the time, and this question keep arising in all our groups, कोर्ट में तो इतने साल से इतने मामले चल रहे हैं. Do you realize that how many and most of the matters are delayed because of the litigants, not because of lawyers? Because we work under instructions.
Right.
So what we need to do is develop a temperament that lawyers can facilitate. Do you know the law? You tell your lawyer to facilitate this resolution process, to expedite this resolution process. Why we are going to court? Why can't we do mediation?
Right.
Why we are doing mediation when something which is black and white? Let's go to court and get damages.
Right.
Vice versa. So this thing needs to change, and probably as lawyers, as law students, we need to build that sort of temperament and community.
Thank you so much for your time, Subhas. My key takeaways from this podcast would be, as a law student, I should be more observant.
Yeah.
Start looking for all the possible opportunities where art is being exchanged.
Yeah.
be it high net worth individuals' office, hospitality industries, or per se wherever it is.
Yeah.
Not to just get into the nuances of it, at least get involved, understand that what matters for the owners and what requires under the transfer of ownership. After that, I would suggest that people go try some internship wherein they get hands-on experience and read more about this and network with people and understand. I think that has been very enriching. As a lawyer, I was also not very informed about art law and its intersection with IPR, but it has been such an enriching session. Thank you for taking out time. We really loved it, enjoyed it, and I hope everyone who is watching you will inspire, get into this more. I will say more investigate about this and will more informed and definitely make a more informed choice about a career prospect regarding that. Thank you so much.
Wonderful. Thank you so much, Chaitanya. And it's wonderful to be part of this series and session. And I hope whatever we could discuss today, it'll build up as a better discourse.
Right.
And we'll have more people connecting with us, through us, to discuss these aspects further. So
Right.
thank you so much. Great being here.
Thank you for watching us. Stay tuned. We will be bringing more guests, more thinkers like Subhas to give you more insight into law. Thank you.